Yes. So first of all, I hope everyone is doing very well. And the movie that I am going to review is not actually a movie. It is a TV drama called Anupama. I am sure most of your mothers must have been watching that, and so was mine. So I'll begin with the backdrop of the show. So the story is set around a couple that has been married for 25 years now, and they have three kids. The husband, Vanraj, he works in an MNC, while the wife, Anupama, she is a homemaker. Now, Vanraj, while working in an MNC, he meets a lady, Kavya, who happens to be her colleague, and he falls in love with her. And apparently, this girl, Kavya, she is also in the process of a divorce. But one thing that is supposed to be noted here is that her proceedings are going on, but yet the court has not given any final decision that whether she could be granted the divorce with whatever grounds she is given or not. So the legal principle that I'm going to highlight here is Section 497 IPC, adultery. Now, the reason why I'm taking it is because, first of all, it relates to a landmark judgment, not to mention Joseph Shine versus Union of India. And I'm sure most of you must be knowing about the judgment, because it is one very important judgment with the point of view of the judicial exam and for common legal knowledge as well. Speaking of which, I'd first like to bring out this section as it reads out in IPC, so that you have a clear grounds on what arguments I'm going to put forward. So Section 497 IPC reads like, whoever has a sexual intercourse with a person whom he knows, or has reason to believe to be the wife of another man without the consent or connivance of that man, such sexual intercourse not amounting to the offense of rape is guilty of the offense of adultery, and shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or both. In such case, the wife shall not be punished as an abettor. Now, I would mention a case law, Joseph Shine versus Union of India. This case law has been, as I said, one very important case law. Now, proceeding towards the facts of the case, a writ petition was filed under Article 32 by Joseph Shine, who happens to be a hotelier, challenging the constitutionality of Section 497, read along with Section 198 of CRPC, being violative of the Article 14, Article 15, and Article 21 of the Indian Constitution. This was the first PIL which has ever been filed against adultery. The petitioner claimed the provision for adultery to be arbitrary and discriminatory on the grounds of gender. Now, the petitioner claimed that such a law demolishes the dignity of a woman. Now, this particular case had been appointed in such a way that a bench of five judges was set up, including one very important judge that most of you must be knowing, Justice Indu Malhotra and Justice Chandrachud. The contentions of the parties were given in such a way that the counsel for the petitioner contended that the provisions criminalize adultery on the classification based on sex alone, which has no rational nexus to object to be archived. The consent of the wife is immaterial here, and hence it is violative of Article 14 of the Indian Constitution. The petitioner contended that the provision is based on the notion that women is the property of her husband, and the provision also says that if the husband has consent to connive to adultery, then it is not committed at all. The provision of adultery is discriminated on the basis of gender because it provides only and only males to be having the right to prosecute adultery, which is violative of Article 15. The petitioner contended that the provisions is unconstitutional and it undermines the dignity of the women by not respecting her sexual autonomy and self-determination. Now, it is said that the issues that are raised in this case goes like this. First of them being whether the provisions of adultery is arbitrary and discriminatory under Section 14. Now, yes, if we read Article 497 IPC, it gives a clear point of view that why it was told that this has to be considered unconstitutional. First of them being, it clearly mentions that a woman is the property of her husband, and that she does not have any clear say in her sexual intercourse. For example, it is clearly said that with the consent of her husband. Now, with that particular statement, it is very clear that the consent of the wife herself does not matter, which is why this is very true. The second issue that was raised in this case was whether the dignity of women is compromised by the denial of her sexual autonomy and right to self determination. Now, here I would like to take you back towards the history of when this article came into being and when IPC entered into this, when IPC criminalized the offense of adultery. That was a time when patriarchy was very much in India, and now, as we all know, that our legal statutes need proper change. And with regard to that fact, this particular section was considered unconstitutional. Whether now, the third contention that was given here, third issue raised, is that whether criminalizing adultery is an intrusion by law in the private realm of the individual. One very important thing here that I would like to highlight is that whenever we read a criminal case, it has to be very important that such case has to deal with the wrong of people at large. Adultery, in the other sense, is not dealing with any such offense that critically violates the rights of people at large. However, it is something which deals with the personal life of the people, and which makes it very obvious that every person has the right to choose who they are going to have their sexual relationship with. So in that very sense, it was concluded that this particular section is an intrusion in the law when it comes to the private realms. Therefore, the judgment was given, and hence the section was decriminalized. But there are several other points that I would bring forward. It is that adultery, anyhow, is less criminalized by the law, but it is more criminalized by the society. Any person who is adulterous is considered in low light when it comes to the society. However, under the Hindu Marriage Act, Section 13 of the Hindu Marriage Act, adultery is very much accepted as a ground for divorce. Any person, whether it is the wife or the husband, can file a suit for divorce if they find out that their husband or their wife is adulterous. Second most important thing here is that if any spouse, or I should say, if the aggrieved party commits suicide, if they find out that their partner is adulterous, then that very person will be charged for abetment to suicide. To conclude, I would like to say that this is the 21st century where equality and liberalism is very much important for every person. And there's a need for legislative reforms, which is why the decriminalization of Section 497 IPC came into being. Adultery is not only a discrimination against women when it comes to sexual independence, and when it comes to society as well. It not only gives the right of male to present women as a material body, but it also demeans the dignity of the women. Therefore, it was inserted as when it was inserted as an offense, it was filed when patriarchy and when paternalism was existing. Now, I would like to say that such case is an important case for us to read, and which is why I chose this particular topic. And with this, I would like to conclude. Thank you so much.